अस्सलाम वालेकुम डियर स्टूडेंट्स, मैं हूं शाहिद रमज़ान स्टेनोग्राफ़र और आप देख रहे हैं मेरा यूट्यूब चैनल प्रोफेशनल स्टेनोग्राफ़ी। आज हम लीगल डिक्टेशन करने जा रहे हैं। ये डिक्टेशन हाई कोर्ट टेस्ट के लिए बहुत हेल्पफुल है, लिहाजा सब स्टूडेंट्स इस डिक्टेशन को लाजमी डिक्टेट करें। मैं ये डिक्टेशन आपको 100 वर्ड पर मिनट के हिसाब से डिक्टेट करवाने जा रहा हूँ। जी, रेडी, start. The view I have been inclined to take and on which some of my judgments are based, is somewhat like this, full stop, where the legislature passes a law, which directly contravenes a fundamental right, that law is, by virtue of the Constitution, void and of no effect, and the courts acting in the writ jurisdiction could strike it down, full stop. But these cases are few indeed, and the more numerous are those where the legislature has exceeded the bounds laid upon its powers by the Constitution, full stop. There, two, the courts need feel no hesitation in finding a contravention and making a consequential order invalidating a statute in whole or in part, full stop. But a third category of case is that where the law is expressed so as to leave a large field open for the exercise of discretion by statutory authorities, full stop. Those who favor the striking down of laws of this count advance the argument that due to absence of guidelines in the law itself, there has been excessive delegation of legislative power to the statutory authorities, and consequently the law is to be struck down, full stop. The view that I was inclined to take in such a case was the fact that of the vacuum did not furnish by itself a sufficient ground for declaring the law to be void, and that the validity of the action taken, which had been brought before the courts for scrutiny, could be determined by the courts while exercising the power of judicial review, full stop. Where all the facts have been brought to focus or have been elicited by the court, using such powers as it possesses in that behalf, it should be possible for the court to say whether the action taken was within the principal purposes of the law as declared in its own provisions, full stop. Where no such contravention could be found and the action was within the main purposes of the act and was justifiable in itself, that is to say, it was not tinged by malefides, I was inclined throughout to uphold the action and refrain from the extreme action of destroying a law made by the legislature, full stop. On that view, conflict with the legislature could be added to the judicial power, full stop. Throughout our political history, the superior judiciary remained active and involved, full stop. There occurred several extra legal constitutional acts and events, full stop. Such events found in the courtrooms, when the courts were asked to pronounce upon the legality or otherwise of such events, full stop.